welcome everyone to our updated webinar from Maryland Lottery to Cannabis Business License, Priorities, Strategies, and Solutions. We'll just kind of start with some initial introductions while we're waiting for others to join. So just a little background on Vicente LLP. Our firm was founded over 10 years ago at this point out in Denver, Colorado. We exclusively focus on the cannabis industry, but provide a suite of services under that umbrella, including assistance, with real estate, leasing, corporate and regulatory services, licensing. My name is Meg Nash. I am a partner in our Boston office and also licensed to practice in Maryland. And really looking forward to, connecting with everyone today to provide some updates on what's been happening since the lottery occurred back on March 14th, and how we can help social equity applicants kind of get up and running in this next 18-month window.
Yes, my name is Christopher Stefan, and I'm the founder of Cannabis Capital Advisors, and we provide brokerage and valuation as well as financing to cannabis businesses, licenses, and real estate owners. And, in Maryland, we're really helping to kind of get the pieces in place to bring these licenses, which now kind of exist as pieces of paper, out of the ground and making them real. And usually that's by bringing in financing or structuring partnerships. So that's what we're here to speak on today.
And hey, Charlie Alvacetti here. And partner here at Vicente. I run the corporate group. My practice is mostly around M&A and helping cannabis companies raise money, whether that be through debt or equity or structuring some sort of, bespoke kind of unusual arrangement, which sometimes could be necessary for social equity licenses because of the restrictions around ownership and control. And I will be living in Maryland full time starting on June 1st.
All right, so we're going to just kind of provide a brief overview of what we're hoping to cover today. Very quickly, just some updates since the December submission, and then we'll be quickly pivoting to kind of the focus of raising capital and what the next steps are for lottery winners. So really, this is supposed to provide kind of the initial 6-month snapshot of what you all can be doing to kind of move your licensing efforts forward. And that's going to have a primary focus on capital raising, securing property, and the supplemental state license application. But before we dive into some of the details there, just kind of give a brief update since our last webinar, just before submission. So there was a total of, I think over 1,700 applications that were submitted as of December 12th, 2023. That resulted in the lottery awards that were announced on March 14th, 2024 via the social equity lottery that was hosted live on the MCA website. We saw kind of a lot of applications for dispensary licenses, about half the amount for cultivation license and half of that on the processing side. But fortunately, all the licenses that were available in those categories, save the Talbot and Calvert County dispensary licenses, have now been selected, and those lottery winners will be going through kind of the due diligence process. So of the 1,700 that applied, about 1,500 made it to the next to the lottery phase that kind of satisfied the minimum criteria set forth in the application. Applicants who were rejected from the initial lottery will still have an opportunity to be engaged in the licensing process. So if you fall into this category, have no fear. There's going to be additional licensing opportunities going forward. You will be able to kind of cure any of those issues in the next licensing round, and can let MCA know, if they request any additional information, just be sure to get that submitted. And then I believe the fee should be waived for the next licensing round as well. So there's still opportunity on the horizon. We expect to learn more as of May of this year, which is just around the corner. Okay, so as I mentioned, we are kind of waiting on the lotteries in both Talbot and Calvert County. There has been some litigation that has caused a delay. There was initially kind of a federal lawsuit under the Dormant Commerce Clause that was kind of dismissed relatively quickly and didn't result in any injunctive relief. But there's been another state court action where essentially the plaintiff is challenging the lottery because she's claiming that she only received notification that she qualified as a social equity applicant 19 minutes before the submission deadline on December 12th. So there was injunctive relief granted there, which is kind of the reason why there's been a holdup, at least in Talbot County. There's a little bit more lack of clarity on the Calvert County holdup. But it does appear as though this is going to kind of move forward. In this litigation is going to move forward through discovery and kind of the overall litigation process. We've reached out to MCA for kind of requests on updates as the timing for these potential lotteries, but are still waiting to receive more information. All right, Chris and Charlie, I'll hand it over to you on the very important topic of raising capital. Again, just kind of flagging that per the proposed emergency regs we saw, applicants will need to provide proof of capitalization within 6 months of receipt of receiving their conditional license. So this is certainly going to be kind of, I think, the forefront of everyone's minds as we move into the next phase of licensing.
All right, so this is just big picture, and I think a lot of this will be in Stefan's turf, but there's a lot of stuff, before you go out to raise money, you want to get a bunch of stuff nailed down so you're not sort of acting on the fly if you get these questions. So some of it is legal, some of it is business, right? So the legal stuff is, making sure you're organized. I mean, some of this stuff will have to have been done, for the application, but like if you don't have an operating agreement, you should have an operating agreement. You're going to have to redo it anyway with the financing, but you don't want to look sort of confused. So my 2 cents on this is ask, either pull something online or ask your lawyer for a form due diligence checklist and just assume that whatever's in the list an investor is going to ask for, and just track all this stuff down in advance so you're able to upload it online, whether it be in Dropbox or some other sort of site. And then if there's any issues that come up right when you're doing this, you're like, oh, we never did X, just do it in advance so that you're not sort of, of course, these are brand new businesses, so the diligence is pretty light, but you still don't want to be sort of like in a situation where someone asks for something, you don't have it. And then, as structuring is just kind of like what we're talking about today, like you have to think about like what are the permissible ways you can raise money in advance. And then the other piece obviously is the key part, which is selling the sizzle, which I'll let Stefan talk about. And that's kind of your pitch deck, your valuation, and your overall pitch for the business.
Yeah, and I really like what Charlie said about going through the due diligence of this, because you're going to need to answer these questions. You're going to need to show to an investor or a lender that you've thought through the answers to these questions and the reasons why. Because right now you might just have a piece of paper, right? And our whole idea is, how do we get this piece of paper to a built-out asset with a certificate of occupancy, right? Because you don't even get your piece of paper until you've built out the business and you've built out the asset and you put the money into it to get everything built out. So it's important to understand what you have and what you don't have. And that will lead to valuation. And when I look at, the numbers of these licenses issued, it's a really significant 874 dispensaries. Do you really think your piece of paper is going to be worth $10 million, $5 million if there was 874 of them issued, recently? And you've got to think about that when you're going to the valuation, because if your number is too high, you won't get a second look. And you have to say, okay, this is the market or county that I'm in. This is how many licenses they're going to allow in that county. This is the population. This is the number of tourists or traffic that flows through here. What is the percentage of that population? What percentage of those are past month marijuana consumers how much are those people going to spend in a year? And, that's really kind of how we get to valuation. And, I wouldn't want to pop anyone's bubble, but I don't see these as, $10 million licenses, and maybe some of them are $1 million pieces of paper. But when you're looking at valuation, I think a lot of these, I think the dispensaries will be the most valuable. But as you move down, it's important to be sober that I think that, there's 872 of these. They weren't all that compared to other states and other application process and other requirements where you have liquid capital in an account. Go ahead, Tara.
Yeah, I think that was the number of total applicants. So there are less than that 874 number that have actually been awarded, and then there'll be some additional, but it's a lower number. It's still high, but I think your point remains true, which is that like this is not like a Florida license, right? We got 1 of 10. Like you can't go out and ask for like multi-million dollars. Well, maybe you can get a few $1 million, but you can't ask for $10 million. So yeah, it's
Yeah. And important to work around the structures, right? And Charlie, I think you can speak to the limitations on equity and equity transfer, and structure of the transaction. If a debt holder or an equity investor can only have right and claim to a minority interest in the company, that's going to impact this as well.
So, we're going to just talk about here, big picture, one issue, so I look at raising money for a social equity license as it's a 3-part challenge, right? Because whatever deal you structure has to work for the company itself, the investor, and the regulator. So unlike a normal deal where it's just 2 parties that need to agree, here you got 3 parties that need to agree. So that's why social equity financings are so difficult, because one, you've got an environment where capital is difficult to access, and then 2, you've got these additional hurdles. So that's why my 2 cents is just figure out the hurdles right now. I mean, and think about it. That's the best you can do in this situation. So one big one is just there is a license cap. This exempts passive investors, so people less than 5%. So it's not it's not kind of the end of the world. I mean, if it was like down to the 1%, it might be a problem. But just be aware of this. And the other thing I would say with investors is, in my experience, 99 out of 100 times, if you have an issue with a regulator and an investor, it's because the investor doesn't want to disclose stuff to the regulator that the regulator wants to see. So you want to have that conversation up front about hey, are you comfortable with these disclosures? All right. So I mean, the big one here is, it's got to be 65% owned by people who qualify as socially applicants, and you can't dip below 65% during the conditional period. After the conditional period, I think you can go to 51%, but you can't transfer control for 5 years. These are some control things, but I was going to say, when you're thinking about the dilution factor, you have to take into account, right? If there's a company and one of the individuals can't be diluted below a certain threshold, that means everyone else gets more than doubly diluted. So if you've got, if it's at 65%, 35%, and you want to bring in an investor for 10%, it's going to have to be 65, 25, 10. This is just some details about what control means. Maryland is nice enough to give us a definition of control. A lot of states are pretty vague on this. Of course, everyone's going to push the boundaries of this in deals. The big one, like the right to veto significant events, this is one that investors will often want in a typical transaction. So I mean, it's, to me, I guess this kind of cuts towards, hey, would a typical venture financing deal constitute control to a regulator? I think Maryland, there's some indications it could.
Yeah, I would say these, are not the regulations that a lender or investor, are looking, these would be challenging to lenders and investors putting the deal together. So an area to maybe work on in your rulemaking.
Right. So, I mean, because, a typical investor is they're going to want a board seat. They're going to want the right to veto things. They want to say on the budget. You know, they want to protect their investment. So this is kind of a big challenge for people, is control. Now, I mean, I guess, you know, the way I would try and frame it is like, maybe you can defend the ability to veto decisions that impact the investment that don't pertain to, say, the operations of the cannabis business. But we'll have to see how this works out in practice. Yeah, so I mean, the big one here is like, you know, debt versus equity. You know, we'll talk about it. I mean, the debt is going to be a challenging thing to raise for a paper license because you won't have any collateral assets to back the loan, and lenders are going to want collateral assets to back the loan. But you might be able to do a debt deal with someone who sees themselves as really an equity investor. And you know, you do a debt deal because it's easy, you know, it provides an ability to structure.
Charlie, what do you think about managed service agreements here?
Yeah, so
That's these are tools that have been used in past programs, you know, to allow for operations and partnerships and give them a little bit more broader range to enterprise.
So, yeah, your typical kind of workarounds that you see in states are some combination of real estate holding companies, IP licensing, option agreements, management service agreements. Now, the management service agreement needs to get blessed. If it's a true MSA, it has to get blessed by the MCA under the regs. The regs also have a bunch of other restrictions about MSAs I think are going to make them difficult to use. My take on this before I even saw these new regs was that a true MSA to me seems impermissible because it would constitute a transfer of control before the 5-year period. So I think you're going to have to scale it back to make it work in Maryland. That's kind of my 2 cents. Yeah, so the big one, the debt side, they have guidance out on this on the MCA website. So you need to be sort of like on the approved list to have a security interest in the license. You can take a security interest in everything else without being on the pre-approved list, but you need a security interest in the license. Another question that I think is open is whether a traditional debt deal would violate the control issue, whether like, because these loans have all these requirements that could constitute control. We've seen other states explicitly come out, like in Massachusetts, and say, hey, you know, the covenants you have in a debt deal don't constitute control, but I don't know what's going to happen in Maryland. So everyone's kind of going to be aware of that kind of like gray area.
And can we take any insight from past decisions with the legacy licensees and transfers, or is there any, you know, case law or precedent as it relates to financing?
I think a lot of these, I mean, you've got a new set of rules that's going to go into effect soon. So I think like the precedent is of questionable value at this point.
Yeah, and if I can just chime in there as well, I think that certainly kind of the 65% ownership and control with the social equity licenses is kind of a new format for Maryland. There's certainly kind of the HB2 licenses, some of which are still in the getting operational phase. But I expect that we'll have a bit more guidance, or hopeful for more guidance, you know, as the social equity licensees get up and running here.
Yeah, and I would say in terms of prior precedent, I mean, I definitely think that Maryland is sort of, you know, on the lookout for deals they think are not kosher. And it's definitely not a state where, you know, you don't see enforcement of these things. Yeah, this is a requirement where you says you can't dip below the 65% during the conditional period, but you can add debt, right? So this goes to my earlier point, which is that like you may want to do a debt deal, not because people want to do a debt deal, but because, you know, it doesn't dilute the 65%. So it may be an easier way to structure a transaction.
I would just flag here too, with respect to timing considerations. To my knowledge, you know, all of the applicants that were selected in the lottery are still sort of in the due diligence phase here. Maybe some have received a conditional license, but I think for the most part, people are still waiting for the kind of formal conditional license to arrive. And because of that, you know, even though you are a lottery winner, you are not yet a conditional license holder. So while it's certainly important to kind of get a jump on thinking about who you may be adding as investors, either above 5% or below 5%. That is a process that's going to have to be approved by MCA. So certainly before you're getting into, or I should say, if it's above 5%, it has to be approved by MCA. Passive investors, there's less oversight there. Passive investors being less than 5%. So, please hold off or consult an attorney with respect to kind of adding or owners or investors without kind of the coupled regulatory process, particularly in this due diligence phase, so that we can, kind of assist in ensuring compliance with what MCA wants to see.
Would you be able to put together a syndication of obviously up to the social equity ownership threshold of passive investors, so to speak, of 5% investors that would kind of potentially allow you a little bit of flexibility in this structuring?
In terms of having less than 5% in multiple.
Yeah, I guess if you had, I guess we could only get to what, 40 or 35%. So 5% passive investors wouldn't have the full registration process. That might be one way to look at this challenge for those listening at home.
Yeah. So I mean, that goes to this slide, which is just that the rules, Maryland used to require addition, anyone required approval. The background check was at 5%, but anyone triggered approval. The new draft regs, which change it from, it used to just be public companies had this 5% threshold where they could add someone without approval, and now it applies to everyone. So that kind of goes to what Christopher's saying, which is that, there may be advantage of adding people below the 5% threshold. Of course, in a typical financing, right, where you've got like a handful of people investing, a typical situation where you got a handful of investing, it's unlikely that any one individual is going to be more than 5% of the raise. But if you're doing a deal where it's like one or two people, that's where you end up in a situation where someone's above 5%. Yeah, so this is just, the new regulations are pretty strict, right? So like, you got to be careful with your typical workarounds, your IP licensing, your management agreement, your options. There's stuff in there that I think would prevent you from putting an option in place today. There's stuff in there that would prevent you from saying, hey, you got to use this trademark for your business. And there's stuff in there that would prevent you from saying like, hey, it's a management agreement where we get 99% of the revenue. So, just, buyer beware here for sure. Yeah, this is just broader, of course. Don't forget, just because it's cannabis doesn't mean federal law doesn't apply. We're breaking one law at a time here. So U.S. federal securities laws say every issuance of securities needs to be either registered with the SEC, the Securities Exchange Commission, or issued pursuant to a specific exemption, right? So with a private offering, almost everyone's using Reg D or 4A2 if it's people that you knew beforehand. But there's state securities laws as well. So, I would just go to this article I wrote, which kind of breaks it down pretty quickly. It's not super complicated. I mean, the state securities laws are complicated because there's, 50 sets of them. But the gist of it's pretty straightforward, which, you gotta be under an exemption here. And I don't want to spend the time here going through all this stuff, but the same things that apply in any equity financing apply for cannabis financing, right? You want to have risk factors and disclosures to protect yourself. You may need to file a Form D. You may need to file state notice filings. Make sure you do that. And definitely don't sell to unaccredited investors is my advice to everyone. We can get into it offline, why. But, you're opening a world of hurt potentially for yourself in terms of legal liability by taking unaccredited money. Yeah, so one good piece of news in Maryland is that there are a few different programs to provide financing from the state, and we know of people that have gotten significant financing amounts from the state. So it's good, like it's up to $5 million. I mean, these are not for this round of licenses, but that's real money. It's not like 50K or something like that.
Okay, so in addition to the Cannabis Business Assistance Fund, there's also the Department of Commerce Capital Access Program. And this is just another way that the kind of administration and statutory authority is seeking to create access to funding for new licensees in the cannabis industry. So this is kind of separate from the fund, and provides, is really meant to kind of entice lenders into the industry. Obviously, kind of with the Safe Banking Act still pending approval, fingers crossed, in Congress, there's been limited appetite for banks to get involved in the cannabis industry. There's a number of banks in Maryland that are willing to work with licensees, though, and we can provide introductions there if helpful to anyone. So this would kind of incentivize lenders to provide loans to licensees. They can enroll in this program, or a kind of all or a portion of a loan can be enrolled in this program. And it also creates kind of a loan loss reserve that's available to the lender in case a business defaults on the loan. So I think it's worth kind of praising Maryland here for kind of the wraparound support that they're really trying to create, again, with Cannabis Business Assistance Fund, as well as the Capital Access Program, and kind of the proactive outreach to private lenders. So in addition to those two programs, there's also the Social Equity Partnership Grant Program. And this is really intended to foster partnerships between existing licensees and new licensees. The Maryland market, kind of the medical market, and the recent AU market that just flipped last July has a number of, kind of successful existing licensees in the market who, can assist with kind of wholesale agreements or, potentially other kind of partnerships or grant amounts that could be helpful with respect to providing services, whether that's employee training or, again, more like wholesale supply chain interactions. So this is really intended to provide grants that would essentially go to the existing licensees, the non-social equity licensee, in exchange for that licensee providing discounted services to new licensees. So again, I think just another kind of proactive step in Maryland to ensure that there's some kind of enticement there for existing licensees, private lenders, and then this Department of Commerce program. So having kind of gone through a lot of these capital raising, whether that's, private investors, capital access program, CBAF, equity, debt, a number of different strategies that you can kind of adopt. It's also imperative that this kind of raising capital process is running along tandem with both a property search, which involves local approvals as well, and the state licensing application, because all of these pieces need to come together to kind of get that final license and get up and running. We're focusing on property and capital raising here, because this is going to be kind of the first landmarks, again, in that kind of 0 to 6 months window. So when we're thinking about securing a site for whatever type of activity, whether you're a dispensary, grower, or processor, there's kind of a number of different legal documents that's going to be involved, primarily, a letter of intent and either a lease or purchase agreement. The letter of intent is really intended to create a bit of flexibility and kind of stop a cash burn right at the get-go while you're securing local approvals. So for example, if you're interested in, a proposed property for a dispensary location, but the zoning laws say that you can't be 1,000 feet from another dispensary, or there's other, kind of local restrictions on that, you're going to want to probably move aggressively to let the landlord or the owner know that you're interested in either leasing or purchasing this property. But, a letter of intent can allow you to say, I'm entering into this letter of intent to secure the property. I'm going to pay basically a reduced amount of money for 3 to 6 months while I make sure that this location complies with all the setback requirements, zoning requirements, and allows me to get any local approval I may need, whether that's a special exception or site plan approval. It's going to kind of vary from jurisdiction to jurisdiction, so that you can kind of minimize the amount of cash that you're spending on a property that you really can't use yet. So that's kind of the idea behind a letter of intent. They're very common in the cannabis industry, again, because you don't want to just enter into a year-long lease for a property for a retail space, only to find out that you can't use that property. So some of the key provisions you're going to want to think about with respect to kind of structuring these is whether or not they're binding versus non-binding. Depending on how long the letter of intent runs, there's likely a benefit to having it be a binding agreement. And because I say that because you are going to have to show proof of site selection and proof of site control with the state licensing application. Ideally, you get a binding letter of intent and then move to the leasing and purchasing phase relatively quickly. But to the extent that you can, you know, to the extent the landlord is kind of would like it to be non-binding, that may be kind of a point of negotiation. The goal again is always to make sure that it's binding and exclusive, so that the landlord doesn't have a letter of intent with, you know, everyone who just won a license in the county, and you all need to fight it out at the local level. We've seen that certainly in other jurisdictions. So feel free to kind of reach out to our team if you need any assistance with a letter of intent and kind of negotiating the structure here. You're also always going to want to include kind of the unilateral right to terminate if all state and local approvals aren't obtained. You know, any number of things can happen on kind of the path to licensure, and you don't want to be saddled with kind of property requirements if you know, something kind of shifts off course. So hand in hand, I kind of touched upon this already with respect to site selection, are the municipal and county considerations. So you're going to want to look at setback restrictions. The good thing in Maryland is that municipalities cannot opt out of allowing cannabis businesses, except for on-site consumption. Those licenses haven't been awarded yet. But they are expressly permitted to create reasonable zoning requirements. So I would say that in my experience, counties are kind of in different phases of enacting zoning. Some have zoning already that expressly contemplates adult use cannabis. Some have existing medical zoning, but they haven't kind of formally converted that to the AU rules. Some counties don't have either, and you need to kind of proactively engage with the local community to figure out, you know, can a dispensary go in any zone that allows retail use? Are there further restrictions? And you may be, you know, one of the first people inquiring about this, since again, this is kind of new to the state. But you just want to be sure that, again, you're kind of taking all these considerations into account when you're working on either a letter of intent or lease agreement or purchase and sale, to ensure you can, you know, the use is expressly permitted, and they're dotting the I's and crossing the T's at the local level. Setbacks are kind of one of the easier things to initially look for. Under the statute, dispensaries are not permitted to locate within 500 feet of a pre-existing primary or secondary school or a licensed childcare center, a playground, recreational center, or library, or 1,000 feet of another dispensary. The kind of 500 feet setback requirement can be, you know, not all that hidden, if you will. You know, frequently, if you just look up an address on Google Maps, you'll be able to kind of see, search nearby, get some information. You may want to look at kind of the Department of Education website too, to look up licensed childcare facilities, because sometimes there are, you know, home daycares that don't pop up on Google Maps. You know, the local zoning department may be able to assist with this as well. But, you know, it can be a bit more obvious than, you know, another dispensary requirement. And this is particularly true where, you know, there's going to be a number of applicants that were selected in the lottery that are going to be looking for property. So for example, you know, if you're in Charles County, can't be 1,000 feet from another dispensary, but there's kind of these private negotiations happening. You know, it's not necessarily going to be publicized that 21 Main Street is, someone wants to use 21 Main Street as a dispensary, and you're looking at 22 Main Street, and, you know, they're within 1,000 feet of each other. They have different landlords. So again, it's good to kind of be proactive with reaching out to the local community, figure out if there's any other applicants who have been kind of identified property to kind of inform this setback requirement, and go from there. And we've certainly seen issues with this come up in New York and other jurisdictions as well. So just something to be mindful of.
There was a good question in the chat on setbacks and how they'd be measured. And I know from my experience that will generally get chopped up again at the municipal level, but do we know, is it, we used to have in Colorado for a while, it was property line to property line. Now it's the closest corners of the property lines. And it used to be as the crow flies, and now we use a directional tool, and it's made some $1 million, challenges on properties.
Yeah, I agree that it's probably going to be chopped up at the local level, and certainly what we've, seen in other jurisdictions, to your point about Colorado, same in Massachusetts. Sometimes the zoning will say, we measure this, from door to door or from property line to property line. When the measurement tool is explicit in zoning, at least that kind of creates a structure that you can work within. I've also seen zoning that there's setback requirements, but there isn't a specific measurement kind of directive in the zoning bylaws as well. So in that case, it can frequently, the approach you want to take there is to present the town with a measurement interpretation that best serves your needs, kind of make the argument as to why this is a rational measurement tool and try to get the town to agree with you. As opposed to asking more open-ended questions as to how are you measuring? Because, if you kind of offer that, they may offer a rule or an interpretation that's not helpful to you. So again, kind of doing that due diligence first on what's going to help your cause, kind of presenting it, trying to get an agreement from the community can be helpful as well. So, but it's a lot of it is going to come down to the local level. But it's kind of a great initial opportunity to engage with the community where you want to locate. Because once you are in, have your kind of site selected, have entered into a letter of intent or a lease, it's going to, be in the applicant's best interest to engage in some community outreach, potentially join a chamber of commerce, something like that. Interact with your neighbors. There unfortunately can still be some relative stigma around cannabis. So kind of having an opportunity to engage with the local zoning board or other elected municipal officials to kind of take away some of the fear to the extent it exists at all is always a positive. I've just included here some kind of factors to consider and research tools looking at different jurisdictions to try to find a site. Obviously, for the dispensaries, you're in a specific county. So that's going to kind of dictate where you're located to begin with. Perhaps many people did this already before they submitted their initial application. But kind of thinking about population, as well as I think the next slide is a map of existing operators, and also looking at where the other approved dispensaries are. That's going to be relevant not only for setbacks if you're a dispensary, but also just kind of on market saturation. If there's already, 3 dispensaries in a 1 mile radius, you don't necessarily want to be number 4. So a lot of this kind of information is publicly available and can help inform kind of your overall business strategy right at the beginning. So just kind of some quick takeaways on the property front before we move to the state licensing application. It's going to be important to be aggressive here and to be diligent and kind of make this a daily practice until you have a site that you want to move forward with, whether that's looking at LoopNet or working with a realtor, working with our team to help with zoning site selection and zoning compliance. The more options you can have to kind of make a better decision, the better. Probably the biggest takeaway here also is to budget for delays. Frequently with property, because you're kind of negotiating with another party to begin with, that's kind of an out of your control element. You have to deal with the local approvals part, another kind of out of control element. So, to the extent that you can just kind of do your best to be diligent and attentive and move this forward, that's going to be the best bet in making sure we're kind of have a property at the 6-month deadline to move towards the state licensing process. Definitely engage counsel for real estate transactions. You know, these are legal binding agreements. So you want to be sure that your kind of best interests are protected there, and have patience, as with all things in cannabis.
Yeah, I was going to say, you can look at these other states, right, as an example. Like, I mean, hopefully it's not as bad as New York, knock wood, right? But look at award of license till actual opening. You know, in terms of thinking about budgeting.
So once you've done all the hard work of raising capital and securing property, you're going to need to start your state license application, or kind of continue to work on this in the background while you're doing everything at once. Once you receive your conditional license, everyone included on the application over 5% is going to have to undergo criminal history records checks, complete a financial background investigation, verify any information that was submitted with the initial application, and kind of make additional disclosures related to, you know, your financial history, professional or business licenses, and in any jurisdiction, and kind of allow MCA to kind of request information from other jurisdictions as well. And then, as we've kind of touched upon, you're going to also have to identify legal control of a proposed site, whether that's through a lease or a purchase or an LOI, a binding LOI. So you may all recall as well, Exhibit A of the application, your operational plan, included a number of attestations about, you know, I agree that I will provide fire safety procedures, medical emergencies, threatening events, security plan, SOPs before final license is awarded. So now is the time to kind of come through, bring all those things to fruition. So certainly kind of looking back at Exhibit A, the operational plan includes an initial outline of all the kind of SOPs that will be required with the supplemental application. There may be kind of additional requirements depending on the license type and the proposed use that will need to be submitted as well. But consider these as kind of a baseline suite of SOPs that all applicants will need to have. Similarly, everyone will have to go through inspections, and this is primarily going to, you know, ensure that the information that's been put in your SOPs matches the facility and layout of your operations. I'll use kind of a dispensary as an example again, since I think that more people are familiar with being in a dispensary setting than a grower or processor. But you know, if in your SOPs you indicate that all orders are going to be fulfilled in a fulfillment room, you know, and then kind of the completed package will be handed in exit packaging to the consumer, then that needs to be reflected in your SOPs. If you say that there's going to be a fulfillment room in your SOPs, but the physical site doesn't have any designated fulfillment room, you know, that's something that's going to be flagged during an inspection. That's, you know, a very obvious example and unlikely to happen. But just kind of want to offer that to illuminate kind of what the inspections will be checking for, that the SOPs, while they can be kind of regulatory driven in terms of, you know, we're going to do X, Y, Z because the regulations tell us we have to, they're also going to need to be personally tailored to the physical site and location, and provide details about how you're going to satisfy that regulation based on the space that you have. So that's something our compliance team can help with as well. We had a great event this past Tuesday where our colleague Casey Levers, the director of regulatory compliance, was there, and she's kind of a queen of inspections for pre-approvals before regulators get on site. So to the extent that we can be helpful there, feel free to reach out.
I encourage you to read and watch our material. It's fascinating. Best time of your life. All right, so let's look at the. Well, I guess no one put it in the Q&A. Everyone just put it into the chat. I was going to say, you want to talk about flipping licenses? Start with a controversial topic. I mean, Sergio has been putting some tough questions in the chat here. I mean, this kind of goes to the heart of it, right? Which is, you know, my take of what was the intent of the regulators here is they don't want you to be able to flip these licenses, right? And I think this is the fundamental tension of social equity financing, right? It's, on one hand, you want to make sure the right people get the license, the right people benefit from the license. I mean, it's more from a regular standpoint. But on the other hand, you need to make sure that they've got the capital they need to actually build out the business, or else, it doesn't really benefit anyone. So, my 2 cents is you're not supposed to sell these licenses within 5 years. And so any transaction you do needs to be very carefully vetted. And you're probably going to have to accept some element of regulatory risk here. That the regulators don't like your proposal.
Are there any reviews between the relationship of the landlord and the licensee that would be deemed ownership? Or is that a
So-
potential avenue for
I don't think
less restrictive
I
than
don't
what we're seeing
I
here?
haven't carefully reviewed the new regulations, but I didn't see any in there. I mean, unless it's sort of like, if it constitutes control, you could get in trouble there. Or if it like violates, if they see it as a management services agreement in disguise.
Yeah, I was just gonna say, I don't think that it's sort of specifically addressed with respect to landlords, but I think that those kind of control and management and services checks and balances, are gonna apply equally to those contractual agreements and kind of subject to scrutiny at the MCA level too.
Yeah.
Yeah,
But what I could see there for a licensee is they found a landlord who had a building that they were willing to build out their building in hopes of having a long-term tenant, and the cost of build out could be amortized in the lease. The cost of the, risk, the hurdle risk for the landlord could be received like a 10 cap or cap rate on your lease, but you may be able to, if not find a landlord who has a building to work with. If the building is for purchase, potentially a third-party investor could come in and buy the building, build it out for you, so your license is issued in exchange for a long-term lease from you, to pay back the landlord and their return on capital. So that is based on, this is all pretty new, right? So, and we're not given legal advice here, but it seems like there might be more flexibility in that sale leaseback structure than there would in traditional debt and equity scenarios, given the rule restrictions. Got some others coming in here. Do you see this one on Cecil County? I think it segues where they're requiring some pretty onerous requirements here, some that I have never seen before. 75 feet from the property line and 1 acre minimal prop. I've never seen anything like that at all. Is there ways to challenge these, or?
Yeah, I was gonna say that, with the question, does that seem legal? There is the language in the statutory authority, the Cannabis Reform Act, that does allow counties to make reasonable restrictions on zoning. So, to the extent that any county inputs restrictions that, are perceived as unreasonable, to the extent that they're saying this is reasonable because of XYZ, I think that it would kind of be legal until challenged, but that may very well come to pass, particularly if, you're working with the realtor or site surveyor that basically says, listen, this is what they put in place. That leaves one property in the entire county that would satisfy all of these requirements, or 2 properties, something that's going to extremely limit the ability to operate in the county. But my kind of gut reaction is that even when there are these oppressive rules, that kind of without challenging them, and whether that's, through a strongly worded letter, or initiation of a lawsuit, those can kind of hold up the local process, unfortunately. I don't know if you have a different take, Charlie, but I think that that's kind of what we've seen elsewhere, and would imagine would occur here as well.
Yeah, and the question and the thing that you always have to look at in these is sometimes they didn't want any. And so they put a poison pill there that you couldn't
Right.
get around. And I fear, in a way, the way this program, the more I research, is that they issued a lot of licenses to social equity, and they made very difficult rules for social equity to get financed, because they knew that would be, just a categorical challenge if you qualify for social equity, because they didn't want to get them up. And if you ask who's they, it's the existing competition. They may have written these rules in a way because they wanted to limit their competition from other MSOs or other, potential
Right.
operators. And if they put out a lot of licenses for people who may or may not have a lot of money and made it difficult for those people to finance them, they wouldn't have as much competition. And that's a fear. And I'm not here to spread conspiracy theories or anything like that, but it's going on right in front of our faces in New York right now, and a lot of these programs around the country, really, to be honest.
Yeah, and our role here is to our goal is to get you up. If you want a license, our goal is to do everything within our power to help you get up and running. So let us know if we can help you. It's definitely tough, but I think there's a path here, and we wish everyone the best of luck, and let us know if we can be helpful at all.
Thank you, everyone.
Thank you all so much for spending your time with us. Our contact information is on the last slide here. Feel free to reach out to the extent we didn't get to any of your questions. We look forward to staying in touch.
We missed Keith. It was the only one to properly use the Q&A, Keith. We can probably type those out to you. Thank you guys so much.